You have no microphone. Speak into the west.
Can you hear me?
I can't. You want? No. Yeah.
Hello?
Okay.
Can you hear me?
Yeah.
Jennifer Canary from Price Me, Shulman, and D'Arminio. As the Township Board is aware, we represent the plaintiffs in pending litigation against the applicant and this board. We would like, for the purposes of the record, to reiterate our position that the board does not have jurisdiction to hear this matter this evening because they are divested in light of pending litigation that asserts a variety of substantive and procedural challenges to the board's prior actions relative to this applicant. We note the numerous substantive deficiencies and noncompliance with the applicable zoning, subdivision, and site plan ordinance regulations and requirements of the applicant throughout this presentation. We join in the substantive arguments that will soon be raised by the Township of Greenwich Council. Tonight, we would like to focus on the procedural deficiencies that the board and this applicant has engaged in throughout the hearing process. It is noted that this in no way constitutes a waiver of any rights available to our client in this matter, and we reserve all remedies available in law or otherwise. The unprecedented fast-track manner in which this application has been handled, specifically 5 meetings in a 10-day period, has resulted in violation of the plaintiffs and the overall public's due process rights. This includes, but is not limited to, the following: failure of the board to provide proper notice to the public of each of the special meetings conducted on this application, and more specifically, failure to provide notice of each meeting in which each of these special meetings were scheduled and voted upon by the board. Limiting the availability of each individual of the public to cross-examine the applicant's witnesses for a total of 5 minutes, and then limiting the ability of the whole public to cross-examine each of the expert's witnesses to a total of 15 minutes. This was done in stark contrast to the time allotted to the applicant. The board's denial of our right to proffer expert testimony. The board acted without a vote in denying that opportunity, which, by the way, was made during the 4th hearing scheduled in 8 days, 2 of which went until the early hours of the next day. The bias and prejudice demonstrated in favor of the applicant and the board disregard for the public's due process right to do so by banging the gavel and not permitting members of the public to speak. Failure of the board experts who were retained just 2 weeks prior to the commencement of these hearings to submit written reports in order for the public to have an opportunity to review and cross-examine each expert. Furthermore, the applicant had originally submitted an EIS, and the board arbitrarily refused to allow questions relative to this critical environmental document. This matter was deemed complete on Wednesday, February 22nd. It is now March 5th, 12 days have elapsed, and this board has chosen to conduct 5 hearings on an asphalt plant application. Not an application that has ever been deemed inherently beneficial or in any way entitled to an expedited review. The variances sought allowed this board 120 days to act. That time frame would have served the public interest to ensure that all were heard, all questions were answered, and rights protected. Surely, it is abundantly clear that the residents of Lopatcong, including our clients, are very concerned. They deserve to be heard and to have had a record devoid of error. We ask that you deny this.
So noted and overruled.
Mr. Chairman, my name is Jay Bone. I'm an attorney with the law firm of Schiller and Pittenger PC. I'm standing in tonight for Mr. Drill on behalf of the Township of Greenwich. Contrary to what the applicant has been saying throughout the course of this hearing, the application does not comply with all applicable zoning, subdivision, and site plan ordinance regulations and requirements. First, the application does not comply with one of the critical conditions required for conditional use, specifically Ordinance Section 243-76. The ordinance provides that conditional use approval, quote, shall be granted only if the same will not be detrimental to the health, safety, and general welfare, close quote, and only if the applicant, quote, shall adhere to the procedures and standards established in the chapter, close quote. The facts are that the applicant did not prove, and the board therefore cannot find, that the proposed asphalt plant use on this site will not be detrimental to the health of the public in terms of groundwater contamination. Greenwich Township provided testimony from an environmental expert that the proposed asphalt manufacturing plant use on the particular site in issue, which is underlain by carbonate rock and a prime water recharge area, would have a negative impact on groundwater quality through contamination and consequently a negative impact on public health. Despite the significance of this issue, the applicant did not see fit to provide any expert testimony on the issue of contamination of groundwater, nor on the health impacts of that contamination. This is not an issue that the board can simply dismiss in the course of its deliberations. This is an issue that should cause the board to deny the application. Second, the application does not comply with ordinance sections 243-48D6A and B, which contain the minimum geologic and engineering design standards related to the presence of limestone. The ordinance provides that the board must find that the applicant has provided, quote, sufficient design and construction information to ensure that the proposed development of the tract will not adversely impact on the health, safety, and welfare of the community, close quote. The ordinance further provides that the board must find that the applicant has provided, quote, specific details ensuring that the design concepts and construction and operation procedures to protect water will be properly implemented, close quote. Without construction details on the final site plans at the time of final site plan review and prior to approval, the board cannot find that the proposed development can be constructed on this specific site without adversely impacting on the health, safety, and welfare of the community. The board should thus deny the application. If the board were to delegate to the Township Engineer's Office the review and approval authority over the details, as suggested by the Township Engineer's Office, the board would be engaging in an unlawful delegation of its authority. The argument put forth by the Township Engineer's Office that this is how it has been done for the past 10 years is not a justification for not following the ordinance requirements. The argument is just proof that the ordinance has not been followed correctly. We urge this board to correct this long-standing mistake and follow the ordinance in this case. Under ordinance sections 243-48D6A and B, site plan approval cannot be granted unless and until the details for construction of the building and structures in limestone geology are included on the final site plans, which are reviewed and approved by the board, not reviewed after the fact by the Township Engineer's Office. For this reason, the board should deny the application. Third, a planning variance is required to provide a private, not public road on which the two building lots will front. This is the only variance that the applicant has acknowledged exists in the application and the only variance for which the applicant has applied. Ironically, however, the applicant's own planning expert conceded that the applicant cannot prove the standards required for the planning variance under NJSA 40:55D-36. In fact, the planner admitted that the applicant can provide a public road without practical difficulty and without unnecessary hardship. The planning expert was quite candid that the reason that the applicant was proposing a private street was to save the township money by the township not having to maintain the new street. In fact, the board's engineering expert testified that he advised the applicant that he would not recommend that the township accept the public road if proposed. As the board knows full well, if the applicant had offered to give the township $10,000 in exchange for the variance, that would be reversed by the courts as illegal. The Township of Greenwich submitted that proposing a variance to create a private street in exchange for the township not having to spend $10,000 on maintenance of the road is equally illegal. The request for the variance should be denied. Fourth, there is no question but that the proposed private street will be a third lot since the street will not be an easement over the two building lots, and the street will have its own lot number. This creates additional variances, however, for which the applicant has not applied. Specifically, the minimum lot area for the ROM zone is 5 acres, and the private street lot is well less than that width. The board should deny the application for failure of the applicant to comply with these zoning ordinance regulations and for failure to have sought variances to permit those deviations. In conclusion, contrary to what the applicant has been saying throughout the course of the hearing, the application does not comply with all applicable zoning, subdivision, and site plan ordinance regulations and requirements. And the Township of Greenwich submits that exceptions and/or variances are not warranted to allow any of the deviations. Without exception and variance relief being granted, subdivision and site plan approval must be denied.
Are you completed that, Bill? Sorry, are you completed now?
Yes.
Mr. Mead?
Thank you, Mr. Chairman and members of the board. I'd like to thank you all for your time and your consideration. I'd also like to take this opportunity to thank the other attorneys for the thoughtful manner in which they represented their clients' interests throughout these proceedings. And of no less importance, I would like to thank the members of the public for their interest and concern for their community and for putting all of the applicant's witnesses through their paces, creating a full record and providing more information. Ladies and gentlemen, this has been a long and at times arduous process, sometimes tense, sometimes emotional, but we have arrived at long last at the end. You've heard from the applicant's witnesses, and they were each subjected to extensive cross-examination. Cross-examination that far exceeded any pronounced time limitation. Likewise, we all heard testimony from an expert witness presented by Mr. Drill, and we all witnessed the cross-examination of that witness. We also heard testimony from 2 environmental experts retained by the board, as well as their cross-examination. The board also brought a geotechnical engineer associated with Engineer Sturgeon's firm, and after that expert's testimony, he was subjected to cross-examination. And finally, we all heard the sworn statements provided by dozens of members of the public. I appreciate the time, effort, research, and heartfelt emotion that went into those statements. The law is instructive as to how all of the information garnered during these 5 nights should be utilized and considered. And I will get to that in a moment. In the meantime, though, I'd like to briefly recap what we've heard over nearly 30 hours of public hearings on this application. As I stated in my opening remarks on February 22nd, the application before this body is one that was previously approved. The applicant already has site plan approval, conditional use approval, and subdivision approval. The applicant believes that these approvals remain valid and remain in force. We are here, however, because in response to a lawsuit that was filed by one of the attorneys appearing at these proceedings, the Township Committee re-adopted the ordinance classifying asphalt and concrete manufacturing facilities as conditionally permitted uses. To be more specific, we are here because that attorney has alleged on behalf of her clients that when the Township Committee adopted that new ordinance, our previously obtained approvals somehow became invalid. That's a legal argument to be made before the courts, but this applicant felt it prudent to instead represent its case in an effort to seek a substantially similar approval now that the new ordinance is in place. What is clear is that the application submitted is a conforming application for a permitted use. The applicant meets all of the conditions set forth in the ordinance, and no one has provided any testimony to contradict that. Furthermore, the operation proposed is governed by a comprehensive set of standards, NJDEP permits, and others. And the applicant has stated repeatedly that it will comply with all such permits and standards. And no one has provided any testimony to contradict that. With regard to the subdivision application, the adoption of the new ordinance has had no effect whatsoever on that previously obtained approval. We included that in this application, however, because as a factual matter, we believe the approvals to be intertwined. We seek only a reapproval as to the subdivision component of this application. That application is wholly conforming with your local ordinance and seeks only a planning variance for relief under the municipal land use law, as the lots created will abut a private street as opposed to a public street. At the outset of these proceedings, the applicant agreed to comply with every suggestion presented by your municipal engineer and your professional planner in their reports. Likewise, the applicant has agreed to comply with every condition of approval suggested by your professionals during the course of these proceedings. During these proceedings, a comprehensive record has been created which evidences this application's compliance with the zoning and site plan ordinances in conjunction with compliance to all other applicable standards. The first witness presented by the applicant was an expert in the field of environmental science. That witness testified that there are no wetlands or riparian buffers on or near the site. He testified that the site warrants no special treatment or additional requirements by virtue of any wildlife. His testimony was concurred with by Commissioner Campbell, the environmental expert retained by this board. The witness was the subject of extensive cross-examination by members of the public. The next witness presented by the applicant was an expert in the field of professional architecture, a licensed architect. That witness described the buildings he had designed and how he designed them, going above and beyond to make them more aesthetically pleasing than what one might expect to find associated with the use proposed. That witness was cross-examined by all interested parties. The third witness presented by the applicant was its director of operation. He reviewed the operations proposed and explained how the proposed facility would function. He affirmed that the operation would comply with all applicable standards, and in response to a request from Greenwich Township, he agreed to restrict truck operations on certain roads in that township. He discussed the seasonal nature of asphalt production in New Jersey and confirmed that the plant proposed will be state-of-the-art, cleaner, and more efficient. He explained that the vast majority of truck traffic would be destined for Route 78 and identified the anticipated number of truck trips on both an average day and a peak operational day. This witness was cross-examined extensively over a period that spanned 2 evenings. The fourth witness presented by the applicant was an expert in the field of air quality and asphalt plant operations. This witness reiterated that the applicant has obtained the necessary air quality permit from NJDEP to operate the facility, and that the operation will continue to comply with all DEP and EPA standards. He discussed dust control measures, monitoring protocols, and emissions, all the while making it clear that the operation proposed by the applicant would remain below the allowable limits established by NJDEP. He confirmed that the plant proposed is indeed state-of-the-art, a natural gas burning facility as opposed to one of the older technologies. In so doing, he explained that emissions generated would be related to the burning of fuel as part of the heating process. He also reiterated that there would be no odors at the property line from this plant, irregardless of what some contend other plants are doing. This witness was cross-examined extensively over a period of 2 evenings. Next, the board presented its own witnesses in air quality and permitting and the environment. Paring it all down, the air quality and permitting expert, Ms. Engel, testified that the plant proposed would meet all NJDEP requirements, even using the worst case assumptions. Former DEP Commissioner Campbell then testified that the proposed operation will have to meet all DEP requirements. He went on to confirm that there are no regulated features on the site and no additional requirements concerning wildlife. He concluded that the applicant, as presented, and the safeguards in place render the site adequately protected. Parenthetically, asked by a member of the public if they would live within 1/2 mile of the proposed facility, both Ms. Engel and Commissioner Campbell responded that with all of the protections and regulations in place, they would. Both of these witnesses were cross-examined extensively. The applicant then presented its fifth witness, a licensed professional engineer. This witness discussed the surrounding industrial uses, reviewed the site design, and reiterated that all required standards would be met. He discussed the drainage plan prepared by his firm. He identified the access proposed and reiterated the applicant's agreement to all of the suggestions posed by Mr. Sturbins and Mr. Ritter. The engineer also confirmed that the applicant's application complied with all of the conditional use standards set forth in the zoning ordinance, and that the subdivision proposed conforms to the zone plan. He confirmed that no trees, as defined by the ordinance, will be removed, and he described the lighting proposed, which will produce no glare on neighboring properties. The applicant's engineer was questioned as to why the private right-of-way was shown as a separate lot designator. And his testimony in response to that question was clear. This was done simply as a proactive measure to comply with the tax map regulations. This right-of-way, he testified, will be attached to lot 6.0 as a single parcel. The applicant's engineer was further cross-examined at length by attorneys and members of the public. The applicant then presented its sixth witness, an expert in the field of traffic engineering. He presented worst-case scenarios and testified that there would be no service level denigration. This witness was cross-examined as well by members of the public. Prior to the applicant calling its last witness, Mr. Drill called his own environmental witness, Mr. Balzano. In essence, Mr. Balzano disagreed with the provisions of the ROM zoning, contending that an asphalt plant is not appropriate for the area. His conclusions related to water issues. Yet, by his own admission, he is not a licensed civil engineer, and as such cannot prepare and submit drainage plans. By contrast, the applicant's drainage plan was prepared by a licensed, experienced civil engineer and was reviewed by your veteran municipal engineer. Further, Mr. Balzano is not a geotechnical engineer. Geotechnical engineers, as we all know, evaluate subsurface conditions. In this case, the applicant submitted an extensive geotechnical report, and you heard testimony from your own geotechnical expert bolstering that report and its findings. Mr. Balzano conceded that he had not reviewed either the township engineer's review of the application or the geotechnical evaluation that had been performed. Under cross-examination from Commissioner Campbell, Mr. Balzano considered that he was not aware that the subject area was classified only as a Tier 3 wellhead protection area. He did not refute Commissioner Campbell's assertion that the use proposed would not be a prohibited use under any wellhead protection ordinance anywhere in the state of New Jersey. Mr. Balzano either disregarded or was unaware of the Highlands Council's finding that nothing in the Highlands Council's approval of Lopatcong's petition for plan conformance impacted the ordinance establishing asphalt manufacturing as a conditionally permitted use. Mr. Balzano could not cite a single study on the effect of asphalt plants on water quality. Essentially, Mr. Balzano set himself up as a super authority based only upon his general knowledge as an environmentalist. In short, his testimony did nothing to show that the application fails to conform to the site plan regulations, subdivision regulations, or other applicable standards. In fact, Mr. Balzano even testified that he had, quote, little doubt that the stormwater plan submitted meets the DEP standards, end quote. As its last witness, the applicant called a professional planner. That witness testified as to his conclusions that the application meets the conditional use standards and is consistent with the goals of the municipal land use law and the Lopatcong Township Master Plan. He also testified that the operation proposed is particularly well suited for the subject site as it is compatible with the surrounding uses and meets all setbacks. He further concluded that the application will have no negative impact upon surrounding properties, all of which, he went on to say, are industrial in nature. He testified that the planning variances were fully justified. He concluded that the application could be granted without substantial detriment to the public good and without substantial impairment of the zone plan and zoning ordinance. Then we heard sworn statements from the public over the course of 2 days. Now, ladies and gentlemen, it's your turn. The testimony has been presented, the sworn statements have been taken, the record has been created. Before you deliberate, though, I'd like to take a moment to speak about the law. The application before you is not a referendum on whether or not the proposed conforming asphalt facility is a good idea on this site. The question is whether or not the application complies with the conditional use provisions in the Lopatcong Township zoning ordinance. And speaking of that ordinance, it is today the law of the land. I know there are a lot of people who are upset with the township for having adopted that ordinance. In fact, most every member of the public who gave a sworn statement was really speaking out against the ordinance, contending that this zone is not an appropriate location for an asphalt facility. Their heartfelt emotion was clear for all to see. And that their emotion sometimes may have turned to anger is understandable. Unfortunately, their anger is misdirected at this planning board. Your charge is to implement the law, to implement the zoning ordinance established by the governing body. You don't make the law. You don't enact the zoning ordinance. Quite simply, your responsibility is to decide this application based upon its conformance or lack thereof with the zoning ordinance passed by the governing body. I would draw this board's attention to the Pizzo-Manton case decided by the New Jersey Supreme Court for guidance in this matter. And I would like to quote a case which relied upon Pizzo-Manton and which I believe is directly on point. The case is D. Maria v. J.E.B. Brook, LLC, 372 NJ Super 138. I'll be quoting from page 147. I'll omit the citations contained within the quote and focus on the substantive language. Here, the board had little, if any, discretion to deny J.E.B. Brook's site plan application since it satisfied applicable zoning and site plan ordinances. The board may not turn down an application in that circumstance because of off-site conditions, nor because of its conclusion that the allowed or permitted use, in fact, is not appropriate for the property or the neighborhood. Ladies and gentlemen, the law is clear. Your charge is clear. And the testimony has been crystal clear. This application satisfies the ordinance, and the applicant will comply with all applicable standards. Given that, I would respectfully submit that the applicant has met its burden of proof and is entitled to an approval. In closing, we would ask that the board consider the site plan and conditional use approval in one motion and the reapproval of the subdivision in a separate motion. Furthermore, if the board rules favorably on this application, the applicant requests permission to submit a draft resolution with findings and conclusions to the planning board attorney for his consideration. Again, I thank you all for your time. I do believe Mr. Bernstein has one or two legal arguments that he would like to make, and then we will conclude.
I'd like to read the living copy. Can you hear me? Yeah? Fine. Can the board hear me?
Yes.
Fine. Okay, I'd like to read from William Cox and Stuart Koenig. It's considered the Bible in land use matters. And this is what they say with respect to all land use applications. First, it should be remembered that each case must be decided strictly on the basis of the facts adduced at the hearing, viewed in the light of the statutory requirements. Hence, the number of objectors present, or the number of proponents, or even the fact that no objections at all are voiced is of slight importance. Decision-making is not a matter of head counting. The board is a quasi-judicial body whose function is to apply the facts adduced at the hearing to the legal requirements of the statute and ordinance, and to decide on the basis whether the request for relief can be legally granted or not. So it's based on the evidence you've heard that you must make the decision. Secondly, as Mr. Menon has stated, you're not here to determine the validity of the amendment that has allowed the plan to be established, allowing the plan to be a permitted use. The validity of the ordinance is subject to challenge either in the Superior Court or the Federal Court, with the township as the primary defendant, not in the planning board proceedings. Third, the relief that's requested, there's a conditional use, that is the asphalt plant conditions, site plan approval, and a planning plan variance. With respect to the conditional use, I'm going to read from Exxon Code USA versus Livingston Township in Essex County, 199 New Jersey Super, 478 pages, 477 and 478. But the essence of the conditional use concept is that every site within the district which is able to meet the objective standards for suitability is entitled to qualify for that use. So the question is not whether you think it's a good use or a bad use, does it comply with the conditional use section of the ordinance. With respect to subdivision and site plan approval, it's the same test. Does it comply with the ordinance? In many cases, the board was confronted, as this board is tonight, with objectors who were opposed to the use. But in each of the cases, they said if you meet the ordinance, you're entitled to relief. Mr. Menon cited the Pizzo-Manton case, which is found at 261 New Jersey Super, 659, affirmed 137 New Jersey 216. And he's also mentioned Demara versus J.E.V. Brooks, 372 New Jersey Super, 138. And also Saratoga versus Borough of West Patterson, 346 Super, 569 active, 2002. I'm not going to read from all the cases. I gave your attorney a copy of the memo I had done. The quotes all say if you meet the ordinance, you're entitled to relief. With respect to the planning variance, we have two lots that are created, two conforming lots, but for the fact they're not on a public street. And the only reason they're not on a public street is your planner wants to save the municipality money. The objector attorneys would have us go to court and say, no, we insist you take this street. We don't think that's feasible. Certainly, it can be accepted by the town. It's built to municipal standards. And as Mr. Menon said, that little right-of-way was shown as a separate lot, but it should be attached to and made a condition that it has to be owned by the same party as Lot 6, which the applicant here is acquiring, and indeed there'll be a maintenance agreement with the owner of Lot 6. Not only will have to own it, but have to maintain it, as Mr. Sturban has discussed. Lastly, we've been told that there are violations by a sister company, and our witnesses have said that plan is going to be raised, but assuming there were violations, that can't stop you from approving this application. I'm going to quote from Levitt and Sons versus Township of Freehold, 120 New Jersey Super, 595 at page 598. Defendant suggests that there is an issue as to whether the plan is entitled to the approval because of the past performance and in connection with other subdivisions. Poor past performance on subdivisions unconnected with the one under consideration by the governing body is not a valid reason for denying approval. Lastly, one of the, actually there were two of the residents spoke and suggested that we give a certain amount of funds, 2%, as a way of ameliorating the impact. I would cite the board and your attorney to Nunziato versus Edgewater Planning Board, which is found at 225 New Jersey Super 124. It's a 1988 appellate division case where the applicant was asked in an apartment variance case, give some amount more housing. They went back and forth. It was an approval. They went to court. The court said you can't be bargaining away approvals by giving contributions. As a result of that case, the decision was reversed, and likewise here, you can't be asking for funds that aren't part of the requirements of the ordinance. I believe these are the legal tests which the board should use in making its determination. Thank you.
Ms. Meeting, ready to please?
We are, yes, thank you.
Thank you. Any comments from the board? Paul? Or closer to the public?
Yes, I'd just like to briefly outline what I feel is the law with reference to what the planning board has to do. In making a decision, the board is required to, by law, to consider the following as they see fit. All testimony of the applicant and its witnesses, both direct and cross-examination. All testimony given by any objectors, either cross or direct. All advice given by the board professionals, including testimony specially retained experts who testify both for and against, and any public comments they believe pertinent to the application. After you consider that evidence, you'll be guided by the law as stated in the municipal land use law, a number of cases already cited by Mr. Bernstein. If the planning board finds that the applicants have presented a case that shows that they have complied with all conditions of the local subdivision, site plan, and conditional use ordinances, then you must vote in favor of those requests. That is preliminary and final subdivision, preliminary and final site plan, and conditional use approval. You should look to the board professionals to advise you whether all conditions have been met, which I think they've already previously testified to that. However, if you are, after considering the above evidence, you believe that they have not fulfilled the conditions of the ordinances, then you're permitted to vote against the application. Again, you should look to the board professionals for advice on this. As to the application for a lot not abutting a public street, you should consider whether the applicant has shown a practical difficulty or unnecessary hardship that they were denied access to the lot, which is a flag lot no longer right of way. There was testimony given by their planner with reference to the fact that he felt it was a hardship for them. In any event, the members of the board are to be guided by the evidence and the law only, should not be affected by other factors. And that's a charge to the board.
Thank you. Any questions from the board?
Remember how we got here.
Thank you, Mr. Chairman. With respect to the site plan, we reviewed this application back last September, and there were very extensive comments on this particular project. We had a very extensive review letter. The comments that were in the review letter touched upon all the issues that we typically look at when we evaluate a subdivision and site plan application. That application was ultimately approved by the board. Our review letter became part of the record and was included in as a condition of approval. Since that time, the applicant has been making adjustments to the plans as they work to try to get other agency approvals, outside agency approvals. So when the plans came in this time to the board with this particular reapplication, the plans reflected many of the changes that the board wanted to see last September when the application was heard. So the number of comments, while from a quantity perspective wasn't that much less than what we were looking at last September, from a substantiveness, they were a lot less in nature. They were very minor in many cases, technical comments. So the plans certainly, from a civil engineering perspective, much improved. And any comments that are in my February 17th report, I wouldn't have an objection to those being included as conditions in any approval that you would grant in this particular matter. Regarding, I guess, the design of this project from a civil engineering perspective, we're looking at two different applications here that are kind of blended into one. We're looking at a subdivision application and a site plan application. With respect to the subdivision, what the applicant needs to achieve in creating new lots is to be able to create access to those lots. And I believe the applicant has done that in a proper manner. There is a private road right-of-way that has at least a 60-foot right-of-way width that is in compliance with our ordinance. There's a 34-foot wide roadway that's proposed within that particular right-of-way to allow ingress and egress for all motor vehicles onto the street and into two lots that are being created. There is a turnaround at the end of the street, which is a requirement of the ordinance. I would note with respect to the turnaround, it is somewhat unusual. Typically with a cul-de-sac, you would actually orient it to the left or offset it to the left because motorists are traveling on the right side of the road and it's easier for them to turn. However, I think that would, in order to do that in a situation, you would end up having to curve the road to the right and back to the left to have that type of arrangement, and it would be cutting into a slope. And as was noted by my partner, Jim Serpico, a lot of the areas where there's a very small overburden between the surface and the karst rock on this site is where the roadway is right now. So we really wouldn't want to remove soil overburden. So I think it's best that we have the roadway left where it currently is and aligned where it currently is, and that's what the applicant has done in this particular case. Regarding site distance, the road has adequate site distance, both at the intersection with Strikers Road. There's some improvements that are needed to do that. There is adequate intersection site distance at Strikers Road. There's adequate safe stopping site distance along the length of the road. It's in compliance with our ordinance. There's a drainage system on the road that will collect the water and convey it to the stormwater management facility on lot 6.07. So that's in compliance with our ordinance. There are shade trees and lights in accordance with our ordinance. So I think with respect to the subdivision, there is a roadway that's been provided to provide access to the two lots that are proposed, and I think it's a roadway that has all the improvements and features that are contemplated by our ordinance, and they've been designed in accordance with the ordinance. So I think from that perspective, I'm satisfied with the plans. With respect to the site plan, and the main issue we're looking at is lot 6 where the asphalt plant is located. I think all the improvements that our ordinance contemplates to support this particular use on the site is there. We have asphalt and plenty of asphalt, and there's considerable asphalt widths on the site to be able to get the larger vehicles into and out of this site in a satisfactory manner. I did take the truck templates, and in fact the largest possible truck template, and actually simulated truck turns in the various lanes that have been provided on the site, and the larger trucks can maneuver on the site satisfactorily. There's not going to be any dangerous turning movements on this site as a result of the way that they've laid out the lanes and the aisles on this particular site. There is signage and striping that's been proposed along the counterclockwise one-way movement that has been set up within the site to basically control that and provide for safety for motorists. There's again a stormwater collection system, and that collection system eventually takes water to the stormwater detention basin on lots 6.07. I believe that basin, subject to certain comments being addressed, does comply with our stormwater control ordinances in Chapter 199. With respect to other improvements, there is lighting on the site that I believe, subject to some comments being addressed, addresses our ordinance. There is landscaping that's been provided as well in accordance with various ordinances. So from a site planning perspective for Lot 6, I'm satisfied. With respect to 6.07, I know we don't have any development shown, we just have a building envelope, but I believe based on the frontage that exists and the difference in the grades between the new roadway and that building envelope, that I believe the applicant can provide a driveway at a future date to a development on that lot and provide a driveway in a manner that complies with our ordinance. So I think I'm not troubled by the way that lot is shaped and the building envelope that's been set up. I think that it can be accessed by a driveway in the future. Thank you.
The applicant has requested two, I'm sorry, George?
I just wanted to add also that the applicant has made a resubmission as part of this application before the board. We did review that effectively January 14th and memo to the board. The applicant has agreed as part of this hearing to provide for changes in various locations on the drawing and also agreed to provide additional landscape.
It's not rocket science, but on your ear.
Come on, I'm sorry. Well, that's it, gotta get closer. Basically, what I said is that we had prepared a review of the application dated February 14, 2012, and in that review of the application that's pending tonight, there were various notations that the applicant had made changes to those, to the plan, as well as additional landscaping, providing additional buffer plans, which he has agreed to as part of this hearing.
Thank you. The applicant is asking for
First vote you're asking for is approval for a site plan, preliminary and final, and a conditional use. So you need to discuss that and make a motion if you so choose.
Any questions by the board? Hearing none. Do I hear a motion for, hold on.
Did our engineer and our attorney agree that? Did our attorney and our engineer agree that they met all the regulations, all the conditions that they were supposed to make? That's what I'm asking.
Can the conditions, I'm asking, can the conditions, are they met or will they be met through the resolution process and conditions?
As I indicated before, I believe that any further work to the plans that's needed, as well as some of the other things we typically incorporate into a resolution, can be made conditions of approval in a resolution. And I do, just for the board's information, if the board is going to frame a resolution of approval, I've prepared a suggested list of conditions. And this is a little different than my February 17th letter. As is customary when I issue a review letter to you, I have recommended conditions. I reviewed all the testimony from the first 4 meetings and had the opportunity to evaluate it and look at a few things. And I have many more conditions than what appeared in the February 17th letter. So if you do frame that type of motion, I'd like to review them for you as well as the public. Has the board made a motion? Yes.
I'll entertain a motion to approve preliminary and final site plan approval and conditional use. Do I hear a motion? Do I hear a second? Roll call, please.
Yes. Members Camperine?
Yes.
Coyle? Yes. Stewart?
Yes.
Wolf?
I'd like to make a comment to the public before I make my vote.
I appreciate all you people being here.
Use the microphone.
Batteries there. Somebody else's.
Yeah, I'd like to appreciate all you people for showing up, whether it be pro or con. It's great to see this many people here. I know this vote is not going to be final. I can see things coming down the line, but the way the applicant has submitted his application, I have to vote yes.
No, you don't have to.
Chairman Van Lee.
Yes.
Yeah, Mr. Chairman, maybe, let me just review the conditions which were applicable.
Please.
Mr. Chairman, if it's okay, I'm going to continue here.
Order.
The conditions that I'm recommending to the site plan that you just took a vote on, as well as the subdivision plan, are as follows. Some of these are rather routine, but let me go through them. The payment of real estate taxes, number 1. 2, the payment of outstanding fees and assessments.
We'll have order in here. Please, Mr.
Suggested condition 3, the procurement of approvals or waivers thereof from agencies with jurisdiction, including the Warren County Planning Board, the Warren County Health Department, and the NJDP. Specifically with the NJDP, what we're talking about is an air quality permit for the recycling facility. It was testified that has not been obtained to date, as well as an EGIPTES permit specifically for hot mix asphalt producers. And that permit number is actually NJ0132721. So those are the approvals that this applicant needs to obtain. Just for the record, the applicant has already obtained some other approvals, so I don't have them in this particular condition. Most particularly, the Warren County Soil Conservation District approval has been obtained. The 4th condition will be applicant revising his plans to address the February 17, 2010 comments of Paul Servants, including comments 2.01 through 2.08, comments 3.01 and 3.04, comments 4.01 to 4.05, comment 5.01, and comments 9.01 to 9.03. Number 5, the applicant revising his plans to address the February 14, 2012 comments of George Ritter, including comment 1.02, comments 2.1 and 2.3, and lastly, comment 3.1. Comment 6, site plan must be revised to indicate the applicant will only utilize security lighting on nights that the plan is not in operation. Number 7, the site plan must be revised to indicate curbing along the easterly perimeter of the asphalt plant facility on Lot 6. In addition, the site plan must be revised to indicate curbs with an 8-inch reveal within Lot 6 where the asphalt plant is proposed. Number 8, the site plan must be revised to indicate no idling signs on Lot 6 at locations to be determined by the board engineer. Condition 9, the site plan must be revised to depict no parking signs within the road right-of-way. Number 10, the site plan must be revised to depict a street identification sign with a no outlet placard at the intersection of the access road with Strikers Road. Number 11, the site plan must be revised to include additional measures on Lot 6 to trap total suspended solids and stormwater runoff, including but not limited to pre-manufactured treatment devices, inlet sumps, etc. The applicant's engineer shall meet with the board engineer to review the appropriate pre-treatment measures and the required site plan revisions. Number 12, the procurement of any off-track easements that are needed to construct the project, i.e. drainage. The applicant shall submit the deed of easement for this off-track easement to the board attorney and board engineer for review and approval The easement shall not be recorded until the board professionals approve the documents and the required board signatures are affixed to the documents. I forgot my number in here, but the next comment, the next condition would be the applicant shall revise the stormwater management plan, including the stormwater outfall design in a manner satisfactory to the board engineer in the event that the owner of lot 6.05, block 100, does not grant an easement for the drainage outfall that's shown on February 3rd, 2012 site plan. Those next one's for 14th condition, the procurement of an absence of presence of wetland letter from the New Jersey Department of Environmental Protection. 15, submission of a maintenance agreement for all stormwater facilities, including the sand filter within the JCP&L right-of-way in a manner satisfactory to the board attorney and board engineer should have been. The applicant should not record the maintenance agreement until such time as the agreement is approved by the board's professionals and board signatures are affixed to the document. 16, the submission of a maintenance agreement for the access roadway that will be constructed within the road right-of-way for review and approval by the board attorney and board engineer. The maintenance agreement shall not be recorded until approval is granted by the board's professionals. The maintenance agreement must be approved and recorded prior to the issuance of a certificate of occupancy for the asphalt plant on proposed lot 6. 17, the applicant shall request Title 39 enforcement from the Township of Lopatcong for the roadway within the proposed right-of-way once the roadway is completed and found to be satisfactory by the municipality. 18, the posting of performance guarantees and inspection fees in a form and amount satisfactory to the township attorney and township engineer. 19, the applicant shall perform no vehicle maintenance on site. 20, the applicant shall not utilize the following roadways within Greenwich Township to deliver asphalt: Greenwich Street, Route 173, Dumont Road, and then lastly Main Street. I believe I got all four there. 21, the applicant shall comply at all times with the noise regulations of the state of New Jersey. 22, the applicant shall install silencers at the top of the storage silos. 23, the applicant shall install sound dissipators on all vehicles that will be utilized in the loading and unloading of aggregate. 24, the applicant shall supply the fire department, rescue squad, and police department with a list of chemicals and their location prior to the placement of the asphalt plant into operation. 25, the submission of the site plan to the Lopatcong Fire Department for review and approval. No construction of structure shall be permitted until the review comments of the fire department are addressed. 26, I was trying to strike 26. Gary told me about that, about Phillipsburg. It's really no longer applicable. Let me move on here. 26, the applicant shall